Now, Pavarotti was a good friend.
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. As a disclaimer, this channel is for entertainment purposes. These are my opinions. I'm not here to slander, so let's get started. Well, today I want to discuss some new documents, and I want to point out a few things on those documents that I think are very interesting. And I think the case is going to get very interesting starting this week. And I know I was fired up a few weeks ago because all the deadlines were coming, but then when the change of venue, we thought everything might get pushed off, weird stuff happened. I tell you what, I can tell already this new judge is ready to get the ball rolling on this stuff because he waits absolutely no time at all to make a decision on things. And I'll show you that here in a minute. I did watch, now by the way, I've been... Goodness, it's been a long week for old Pavarotti. I've been working from before the sun comes up to well after the sun comes down every day this week, so I haven't been able to do much, and that's why I wanted to get this video out, get updated on the things that I haven't posted about. I know a lot of y'all have already seen some of the information on these court docs that came out, but I know some of y'all wait for me to relay this information to you, so that's why I'm doing this. Also, of course, I'm going to point out a few things other people don't. But I did watch. I didn't catch, much news this week, but I did watch an episode. It was the law offices of Andrew Myers, and he was discussing one of the documents. And at the end of one of the documents, he pointed out the fact that they didn't have Bill Thompson listed under, being notified of the hearing that's coming up. And he was suggesting that meant that Bill Thompson would no longer be on the case. Now, when I heard him say that and I seen that, I went, oh my goodness, that would have profound implications on this case if Bill Thompson was not the prosecutor. And let me tell you why. Bill Thompson has the intermediate relationship and all the knowledge of all of the informants in this case. As I've pointed out in the past, he has been part of the process for promoting the deals the informants have actually taken. And he approved them. He's got full knowledge of them. And he even put in his response to the alibi statement that if push come to shove, he would need a little time to prepare a list of witnesses that could place Bryan Kohberger at the scene of the crime. So what he stated in that response to the alibi was, I have confidential informants that if push comes to shove, I'll need a little time because I will turn those confidential informants into cooperating witnesses and present a witness list. So when people tell me that there's no confidential informants, Pavarotti, really? Well, then how's he going to turn people that don't exist into witnesses that can place the defendant at the scene of the crime? He's got confidential informants. He has confidence in his confidential informants. It's my perception and my belief that his confidential informants have sold him a bill of goods on Bryan Kohberger because of their involvement in the atrocity. Regardless of what I think, though, Bill Thompson has confidential informants that he has proven in writing that he can turn into cooperating witnesses. So, and these are people that obviously have intricate knowledge of things that went down at King Road, or else he wouldn't put in there that he's going to turn cooperating, he's going to present a list of witnesses that can place the defendant at the scene of the crime, folks. I mean, it's right there. Anyways, back to what I've went off on a tangent now. I forgot even what I was talking about. Oh, so if they took Bill Thompson, or if Bill Thompson took himself off of this case, then I can assure you the entire case would implode in a matter of minutes. Because number one, they're not even promoting to the public what this case is really about. I mean, I'm going to do a video here this week for you, and I will once again prove that the prosecution knows that there's two assailants at least in the case. And there is a co-defendant that is going to be presented in this trial. That is the state's case, and I will prove it once again with different evidence this week, though. I've come across even more. So, but with that being said, when I seen that, I said, goodness, I'm going to have to dive into these court docs and just see if there's any validity to that claim. Because, I believe that Andrew Myers is very smart. He's an attorney. So here's what I found. I want to go over some of these docs with you, and I think you'll find them interesting as well. And let's just get right into it. Okay, here's the first one I wanted to talk about, because this is the one where they're giving notice. We've got a hearing, a status hearing coming up this week, Thursday, September 26th at 2 p.m. So Judge Hippler is not wasting any time, and that is a good sign. He is on top of things. He's already scheduled a status hearing. I imagine this is going to be a status on where we're at in the case, and then he'll start to schedule the rest of the hearings from this point out. So, and the thing that he pointed out, that Andrew Myers pointed out, was down here, certificate of service. You can see by email, they emailed Jeffrey Nye and Ingrid Beatty, and then of course Massoff and Ann Taylor, and that was the only people that was listed on the email certificate that was getting notification of the hearing. Now, does that mean that Bill Thompson's no longer on the case? No, it turns out it doesn't. What that does mean is Bill Thompson may not be in that hearing, because I believe going forward, Bill Thompson is going to allow the other folks, particularly Miss Beatty, because she's proven to be very, very sharp in the courtroom. He's probably going to allow them to handle a lot of the hearings coming up between now and the trial, because that's a long way for him to travel and he has other responsibilities. But I don't think this means he's off the case, and the reason I say that is this notice went out on the 19th, and if we look, what I did was pull up, this is old notice of hearings, just to see if there was anything different, right? We got a motion hearing that was a notice for a hearing on May the 2nd. And the way they sent out that certificate is they sent emails to Ann Taylor, Massoff, Beatty, Nye, and Thompson. So I went, well, maybe there is some validity to that claim. So I pulled up another one. Notice of hearing, this was for April 4th. And again, by email, William Thompson, Nye, Beatty, Massoff, and Taylor. So I said, well, okay, well then maybe he's right. Maybe no more Thompson. But then I looked at the order the day before, September 18th. This was the order for courtroom conduct. And I'm not going to go through that whole thing. I know other creators have gone through it word for word. I didn't see anything in there particular, except for a couple things that I am going to point out. But I'll point out those things here in a minute. But on this certificate of service that was sent out on September 18th, the day before, you can see it clearly lists William W. Thompson Jr., Ashley Jennings, Latah County Prosecuting Attorney's Office via email. Then they sent it to Nye and Beatty at the Office of the Attorney General, Ann Taylor, and Massoff. So if he was no longer on the case, then I seriously doubt that they would be sending him the certificate of service for courtroom conduct. So he's still there, folks. But here's something that I did want to point out. And this is how efficient this new judge is. You can see this is September 20th. The District Court of the 4th Judicial District in Idaho. We have KTVB News. All right? They sent in a request wanting to actually be able to photograph and broadcast from the courtroom. And you can see that same day that request was denied. They said it did and was denied immediately, and that judge made a ruling, got it back, and was like, nope, get it out. We're not wasting any time. So that is a very good sign. But here's the other thing I wanted to point out. And on that same order for them, KTVB, okay, this is their request. I'm sorry, that was the denial. This is the request. And during the request, they stated how they have read Court Administrative Rule 45 and everything in there. And that's important. Now, he denied this request in a record amount of time because apparently he's very efficient. But he denied this request. Wait a minute here. Let's see. This date was 9/26/25. Okay, they were requesting for the hearing. Okay. But he denied this request in a very fast amount of time. And in the request, they cited Idaho Court Administrative Rule 45 because in his rules of conduct for the courtroom conduct, the judge specified Rule 45 several times. So here's one thing I wanted to point out about Rule 45, and I don't know that this judge would play around with this, but it talks about cameras in the courtroom, but it also, in this coverage, if the judge really wanted to, he could clamp down some sanctions. Audio-visual coverage, as used in this rule, means broadcast, video, audio, and photographic coverage. Now, broadcast is different than video and in the courtroom. That's actually broadcasting, and that could be live or it could be post-broadcast. Photographic coverage or recording of public proceedings before district and magistrate judges. Broadcast, right here, means the transmission of images or sounds by any electronic means, including but not limited to television, radio, internet, email, or streaming. Audiovisual coverage is authorized subject to the discretion of the presiding judge. The presiding judge maintains the right to limit audiovisual coverage of any public hearing when the interest of the administration of justice requires. Authorization may be revoked at any time without prior notice when, in the discretion of the court, it appears that audiovisual coverage is interfering in any way with the proper administration of justice. So you can read that, and the way that rule reads is this judge has the ability on people broadcasting via internet or streaming. He could clamp down sanctions even on people restreaming things on YouTube and cite proper administration of justice. And here's another part to that Idaho criminal rule. I just think everybody ought to be aware. It may be a rare thing, but the request for approval to video record, broadcast, or photograph a court proceeding and order granting or denying such request should be in substantially the form approved by the administrative director of the courts. Okay, so I'm going to read this one more time. The request for approval to video record, broadcast, or photograph a court proceeding. Broadcast. You know, a lot of people on YouTube like to take the court proceedings because it's posted on a YouTube channel and then they broadcast it on their own channel. They may be careful on this one because you have to have an order granting or denying such request, and it should be in substantially the form of approval by the administrative director of the courts. And I'm just saying that simply because of how fast where are we at here? How fast that this little television station was denied access to video to record it. But you can see request for approval to video, audio, record, broadcast, or photograph a court proceeding under Rule 46. And their request was denied, and it was denied, and it says it's going to be broadcast on YouTube. But I mean, I don't know. I think the rules on this are kind of cloudy, and I think if the judge wanted to, if he wanted to clamp down on people on YouTube without them having approval to restream it or broadcast it, then you know what, he could possibly clamp down. So it might be something just to take into consideration, or I might just be being overly cautious. I don't know. So anyway, it says September 26th, this Thursday, we got a status hearing with a new judge in the new courtroom. And I'm excited for that one. I will be giving you my thoughts on that one afterwards, because I'm hoping that as proficient as this judge seems to have been so far, that he continues to be proficient and he starts to put the things in play that should have been put in play a long time ago. But I'll be excited to report on that one. And also, I'm about to, here probably in a couple of hours, I'm going to release part 3 of my motive series. I know a lot of you have been waiting on. And again, I've been really hard at work this week, so I haven't been able to complete everything on there up until this point. It's completed now. In fact, I've got it uploaded. I'm about to release it to members, and I'll release it to the public here in just a little bit. But I did put it off a little bit longer than I expected to because, and I have nothing against any of these other content creators out there. I did post a post the other day, and I wasn't saying that, I wasn't trying to demean Tommy Jude in any way. I mean, I think he's a great guy, and I like him. But I actually had a lot of people commenting on one of my videos, and when I was reading their comments, they were telling me to go check that out, and then I pulled it up and I watched like 15 minutes of it, and I was like, oh no, I don't know what's going on here. So I hurried up, I turned it off, and then I did put out that post just to let my viewers know my opinion on the subject. I have nothing against Tommy Jude. Again, I think he's a great guy. I just wanted everybody to understand that what was being said was not not my point of view. But I just wanted to get that out there. But in the meantime, please like and subscribe to this channel. Post your comments, thoughts, criticisms. And until next time, Pavarotti's out.